One of the sad things that we end up having in our societies is having to protect our children from sex offenders.
Yes.
The amount of attention that the media has been placing on sex offenders has grown exponentially over the last few years.
Right.
Part of the reason is that law enforcement has gotten so good at identifying them and bringing them to justice. You are the one, or your office is the one, that has to put these men and women into a court of law and prove guilt.
Right.
Can you talk to me a little bit, I guess, how your job has changed over the last few years since we've sort of changed the way that sex offenders are classified in our state?
Well, the classification with the state law has not changed a whole lot. What has changed is the sentencing requirements for a sex offender, and in particular for a sex offender who commits a crime and has a victim, who has a child victim. And what's happened is there are minimum mandatory sentences, and there have been changes in the good time system, the system by which a state inmate will earn good time towards an early release from prison, and changes regarding probation. Those two, and you can call that parole if you like, but between parole and probation, the changes have required a minimum sentence, either 10 years or 20 years, depending on whether it's Class A or Class B felony. And they have also disallowed any early release, basically, for someone who is sentenced to prison for these crimes. So the plea agreement, that process leading up to a trial, you have a lot less room to work within that, because a defendant charged with a crime, if he knows he's going to prison, knows he's has no chance of getting probation, knows he has no chance of getting out early, then he'd rather make us go to court, make us bring the child victim in, and go through the rigors of a trial. Sometimes that is impossible. Sometimes, well,
Sorry, start over.
yeah, no. I mean, I'm trying to think if that's the right way to word it. Some children can't do that. For some children, going through a trial, facing the person who has violated them, who's raped them or sodomized them, and sitting in a courtroom 15, 20 feet away from them, and having to face them is too traumatic. They just can't do it. And often we rely on whatever counselor or psychologist or psychiatrist is working with the child at that time. And we have situations where medical profession or the therapist steps in and says, listen, you're going to do more damage to this child by forcing them to go into court and testify than you will by letting the offender walk. And in those situations, we really try to, we don't want to re-victimize someone. And we come into that process of trying to reach a plea agreement. With the mandatory sentences, that can be difficult. That can be difficult. And we have the option of reducing the charge in the crime to try to avoid the maximum sentence. You know, if someone's facing a mandatory 20 years, day for day, and the child is going to be unable to testify such that we're going to be unable to prove our case, then we look to that 10-year sentence and decide, one, is this what's best for the community? Two, is this what's best for the child? And three, can we live with this? Can we live with this result? Is this going to be justice for what happened? Now, as far as the tier situations in Alabama, everyone is pretty much on the, except for situations involving juveniles, a juvenile charged with a crime. I guess you could consider that to be a different tier. But other than that, all adult sex offenders in Alabama are on the same tier when you compare that with the federal system. And that tier requires them on the back end of the case, whether they go to prison or whether they receive probation. If they have a conviction, then they have to register for life with local law enforcement. And there's a certain amount of community notification that goes out for that. Now, in the federal system, depending on the crime and the elements of the federal crime, they may be allowed to petition for an early release from the registration requirement and the reporting requirements. I believe there's a 25-year on Tier 2 and a 15-year on Tier 1. No, on Tier 3. I guess it goes 1, 2, 3. So that's a little bit different. In Alabama, you'll have to register for life. And you'll be a sex offender registering with local law enforcement, and there'll be community notification for life if you're an adult offender. If you're a juvenile offender, it's a little bit different. It's up to the judge to decide. With certain crimes, the judge does have some leeway on whether they have to register for life and whether there's community notification.
Now, would that fall into the realm of the different kind of cases? For example, you have a 20-year-old male that chooses whether it's right or not, to have a relationship with a 16-year-old female and be brought up on charges, even if though that was a consenting situation. That 16-year-old, as I understand, is still listed as a juvenile. Is that not correct?
Well, in Alabama, you're really talking about two different things. Okay. At age 18, you are treated as an adult for criminal charges. So if you're 18 and above and you commit a crime, regardless of the crime, you're charged as an adult. If you're 16 or 17 and you commit a Class A or Class A felony or a felony involving serious physical injury, a felony involving a deadly weapon or dangerous instrument, then you are automatically treated as an adult at age 16 or 17. But that's different than the age of consent in Alabama. In Alabama, the age of consent is actually 16. So for your example, you would have to go down to 15. And what you're talking about there is if you have an adult who is 20 and a juvenile who's 15, then that, even if it's consenting, even if it's a consensual relationship, is a second degree felony. It's rape second degree or sodomy second degree.
So the code was rewritten last year. How did that change the way that we're classifying what is and what isn't a child?
Well, it didn't change the classification. Okay. For the example that we're working with, a 20-year-old and a 15-year-old, okay, that's going to be a Class B felony. It's rape second degree or sodomy second degree. And what the law says is that if someone is under the age of 16, really between the ages of 12 and 16 is what it says, and they have sexual intercourse with someone who is older, 16 or older, and at least 2 years difference in their age, then it becomes rape second degree. What's commonly known as statutory rape. That's the phrase that most people are familiar with. And it's a Class B felony. So the requirement of the 10-year minimum or the 20-year minimum doesn't apply to that, because the definition of child, when the law says that there's a 20-year minimum or a 10-year minimum for having sex with a child, and we're talking about sexual intercourse with a child, we're talking about sodomy and sex abuse. No, excuse me, just sodomy and rape. Then if the child is under the age of 12, that's the definition of child that they're using to determine whether it is 20-year minimum or a 10-year minimum. But for rape second degree, statutory rape, you're looking at that age between 12 and 16, and you're not treated as a child for that purpose. And I know it's a little confusing, but when you look at the statute, it starts to make sense. And so in Alabama, what you have is a situation where you can have a 15-year-old dating a 17-year-old, and the law looks at the difference in ages and goes by 2 years, looks at the birth dates. And if there is more than 2 years separation in their age, then it can be criminal activity for sexual intercourse or for oral sex even.
So 24 months and 1 day, you're treated differently than 23 months and 30 days.
Yes, yes. I mean, one is a criminal charge and one is not. And that is something that there's an Alabama Criminal Code Committee that is put together right now that's going through the entire criminal code and looking at it. And this is judges, prosecutors, defense attorneys. And that's one of the things that this committee is looking at, and looking to see what other states have done as far as whether to make that a 3-year, make it a 4-year difference, or make it a sort of a sliding scale, that the older the age of the younger person involved, then the wider the gap needed for a charge, and then narrow that gap as the child gets younger. And other states have done that. Some states have a 3-year period, some states have a 4-year period. So yeah, I mean, it's when you're talking about the possibility of a sexual offense, a crime, for a consensual relationship between a 15-year-old and a 17-year-old, or a 15-year-old and an 18-year-old, you know, it does change things. You start looking at it and saying, okay, this is a consensual relationship, and even though Alabama does not recognize that a 15-year-old could consent to sexual activity, you really do look at that and say, okay, what is going on here? I think everyone has seen that situation, you know, and the one that comes to my mind is out of Texas, where you had and I don't know the Texas statute, I don't know the ages of the respective parties, but there's a man who is a sex offender. He has to register every year as a sex offender, and he is now married to the victim in the case, and they have children, and he has to get special permission to go to his children's high school activities because he's going to be around children because of how the Texas statute was written. And that's what everyone's trying to avoid, is that extreme. And for that reason, yes, you do have to look at this a little bit differently. But you know, being a father of 2 daughters, you know, you're going to have a hard time convincing me that there is a right age. I mean, you know, 25 is going to be too young for me. I mean, it's, you know, for when you're really talking about parents and their children, it's not such an easy discussion. It's not black and white. And you know, should it be 3 years? You know, is it any better if it's a 16-year-old and a 14-year-old? You know, again, as a father, I'm going to have a hard time accepting that. That's going to be okay because of, even with the 2-year difference. And then you start looking at it and saying, okay, should we say 16 and 14 is okay? Should we say 16 and 13? Should we say 16 and 12? And when you start trying to create that period of time, that age difference that you say is okay, it's very delicate. It's very delicate trying to create a law that everyone's going to agree with.
When you look at the ambiguity, and this example, I mean, like that, and then you look at this federal tier 3 system,
right?
Do you feel that is something that is even remotely possible that the state of Alabama should look into, or does it not work on a state level?
No, it could work on a state level as well. I mean, it takes some time to sit down and go through this and decide what is best for the people of Alabama, what is going to protect them, you know, what's best to protect children, protect victims. Sex offenders, you know, I think we really don't have a grasp as a society on what is the best way to protect society from them. And what we've found, what we've come up with, is these registration requirements, so that the local law enforcement knows where they live, knows where they work, and will always know where they're going to be, unless they're violating the law. And then the notification goes out to the neighborhood and goes out to everyone that lives around them. But you know, the question becomes, should that be required for the rest of their lives? And every situation is different, and we're trying to come up with, or at least the legislature, you know, state legislature is trying to come up with a one rule, a one size fits all plan, and it is difficult. It is difficult. But you have that in all areas of criminal law. You know, one of the things that other states are looking at right now with offenders is trying to come up with basically a classification their risk to reoffend, and to determine how much control, supervision they need over them for all crimes, and trying to do so responsibly, but also trying to do so efficiently. What resources does this person require? What penalty and level of supervision on probation or level of supervision on parole will best suit this person? One, to make sure that they don't reoffend, and two, to make sure that the public is protected. And we're not there yet. We've got good systems in place, but I can't say that there's one that's perfect yet.
I think that one of the problems that we run into, and I see this when we're putting together our stories as well, is that we tend to lump all sex offenders together. We hear that somebody's a sex offender, and we automatically assume that they're a child predator.
Right.
And that's not necessarily the case. There's all realms, and that's the reason why this classification system is such an interesting topic for us. But when you hear, like, I don't know if I sent it in the email or not, one of the things that was a kickoff on this is that we had a sex offender that was from Russell County. In 2000, he was sentenced to 6 years. I believe he only served 25 months of the sentence. He now was relocated to Cincinnati, but he's trying to advocate changes in the way that sex offenders are I guess, classified in the way that they are punished following their sentence.
Right.
And one of the things that he argues is that, when somebody shoots another human being and kills them, and they are released on parole, nobody, unless they go back and actually check the criminal history of this person, is going to know that they have a murderer that lives next door.
Right.
But anywhere this guy goes, everybody knows that he did what he did, as horrible as it was.
I think that's a reaction to what specific instances that have happened around the country. And I certainly can't give you the numbers, but we all know that there are instances where sex offenders reoffend. They get out and end up living next door to or in the same house with a child and reoffend. And there's been research and studying done to determine their level of the levels at which they're going to reoffend. The recidivism rate, and actually talking to them. I think there are child sex offenders out there who say that they're never going to be able to overcome this, whether you call that a crime or a medical condition. So it's not like someone stepped in and just said, "Hey, sex offenders are bad, so we're going to put this extra burden on them," and quite frankly, you don't have as high recidivism with something like homicide. It's
crime of passion versus crime of opportunity.
Yes, crime of passion, or crime of passion versus a crime of opportunity, a crime of planning, careful planning, sometimes grooming. The situation. A lot of the situation that we see is they do have the opportunity, but they, with children, a child predator will go to great lengths to groom a child for what he or she is going to do to that child.
On a personal level, and I know that you don't prosecute yourself, but your office does on all these cases and everything like that, but when your office is not successful in proving somebody who, without reasonable doubt, you just haven't been able to, for whatever reason, on a murder case, and somebody gets manslaughter or pled down or whatever it is, and they're in and out, versus when you're going after a case that involves somebody that has been a predator against children or been accused of being predators. Is that harder to accept afterwards? Do you understand what I'm asking?
Yeah, I think I do. I mean, it's certainly, there are dozens, hundreds of cases where a crime is committed, and we are able to look at what a jury, look at and see what a jury is not going to see. We are going to see their criminal history. We're going to know their background. We're going to know their reputation in the neighborhood. We're going to know information from the local police, officers who work the beat, who are going to say, yes, I've seen this person do this dozens of times, or he's just been, I've been just this close to catching him so many times. And I'm not talking about violent crimes, but burglary or robbery or drug crimes. And what I'm saying is, it's not always what we know, it's what we can prove in court. So you have to, on some level, you have to treat all cases the same because you have a legal standard that you have to prove. So with that in mind, anytime we know somebody committed a crime and we can't prove it, it is extremely frustrating. But certainly when it is a violent crime, it is more frustrating. It is you walk into court and you have the case that you have. You have the facts that you have the evidence that you have, and sometimes you can prove it beyond a reasonable doubt to the jury, and sometimes you can't. We're not going to go into court. We're not going to pursue a case unless we believe that they're guilty and we believe that we can prove it beyond a reasonable doubt. But a jury doesn't always agree with us, and sometimes that's not just because of the evidence in the case. Sometimes it can be something in their own personal lives that we weren't able to ascertain in jury selection. It can be the way the wind is blowing across the nation at the time. There are so many factors that shouldn't affect a jury's decision that can and do. I mean, it's just the reality of what we do. So you can't let yourself get bogged down by those unpredictable variables. You identify as many as you can. You prepare your case. You talk to your witnesses. You talk to the police, and make sure that you've got everything that you can legally present. And then you walk into court and do what you can. And sometimes the judge agrees with your position of the law. Sometimes the judge doesn't. Sometimes there, evidence that you think is perfectly admissible, the judge that day doesn't see it that way, and never, the jury never gets to hear it. One of the interesting things in Alabama, well, not just Alabama, but one of the interesting things about the criminal justice system is that if a defendant who's charged with a crime doesn't make a statement to the police, asserts his right to an attorney or a right to remain silent, when you get to trial, when you get to court, the prosecutor can't comment on that. So if a defendant takes the stand and he testifies, you're hearing on the witness stand for the first time his version of the facts. The defense does not have to provide that to the state. They don't have to give that over. They don't have to tell you what their defense is going to be. And I think oftentimes a jury is sitting in the jury box and thinking that the state, that the prosecutor knew that story. Well, a lot of times we can guess. I mean, we can make a pretty good guess when it's going to be self-defense or alibi, but we don't know what the defendant's going to say, and we don't know what the defense witnesses are going to say. The defense does not have to give us a list of witnesses, does not have to tell us who is going to testify or what they're going to testify to, unless in certain circumstances where it's an expert coming in to testify. So I feel that often a jury is looking at us thinking, because they've watched TV, movies, CSI, Law and Order, they're looking at that going, oh, well, the prosecutor knew this person was going to say that. And we didn't know it until, oftentimes, till it came out of their mouth on the witness stand. And that's difficult. It's not, that's not true for every state, but it is true for Alabama. That's the rules of evidence and rules of criminal procedure that we work with in Alabama. And I don't think a lot of people know that. So I often feel like I'm standing in front of a jury, that the jury's saying, oh, well, you knew this. You knew he was going to say this. You knew this was going to be the evidence. And we didn't. And we're reacting and trying to proceed with the case. A judge wanting us to go ahead and will often give us a little bit of time to check something, maybe to call some witnesses or ask an investigator to go check on something that the witness testified to. But it's not going to be days or weeks. It's going to be hours. And if you can't find it, you just have to proceed with your trial as best you can.